Very much, Peter. So thank you, Peter, and Irish Studies for having me, and thank all of you for coming along. It's lovely to see old colleagues, old supervisors, some old faces, an old student in the mix, and some people that got over the line at the PhD shared an office with me at the same time. So it's lovely to see people and new people as well. So thank you very much for coming. So as Peter was saying, my PhD had focused on the period 22 to 37, so that was between the two different constitutions. That was why I picked that particular block of time. So 1922 to 2022 seems like quite a big period to be investigating, but I'll explain later why it's 2022. I had focused on the translation section, Rano Ganastrahan. You're going to hear the term Rano Ganastrahan a lot. So if you don't speak Irish, it's the translation section in the Oireachtas in Dublin. So I had focused on that, but now that I work in the European institutions, I'm going to bring in how they set about their terminological work. I'll have to learn how to say terminological before I finish this too. So so this is basically just to give you an idea of what all I'm going to be covering. So I'll give a background to legal translation in Ireland in general, sort of whatever kind of historical and linguistic background that went against the formation of Rano Ganastrahan. Translation of Irish language legal terminology in Republic of Ireland, so focus on terminology specifically, and then I'll give some examples of how certain legal terms have been translated or perhaps mistranslated in the Republic of Ireland. Then I'll cross over to the European Union, so give a background as to when Irish language legal translation started in the EU, and then bring in specifically how legal terminology is dealt with, and then draw some conclusions. So, in what historical and linguistic landscape then did legal translation in Ireland begin? On January 21st, 1919, at Mansion House in Dublin, the meeting of the first Dáil took place with candidates elected in the 1918 Westminster elections who refused to recognise the Parliament of the United Kingdom, establishing an independent legislature. The primary language used on this first day was Irish, and as Seamus Staltoon recounts, Brod specially go crohiú an leishin groise daco na gnélig, cursi politiach de flay agus grohi parliamentia cur Greek gan caigriha. So it was particularly interesting in that it was established that day that it was within the capacity of the Irish language to discuss political matters and fulfil parliamentary activities without foreign assistance. So with this in mind, proceedings of the Dáil would henceforth be recorded in both English and Irish, and as such, Micheál Ó Lynchy was appointed as official translator. While embryonic in form, this appointment instituted the translation service in the Dáil, the origins of the current Oireachtas translation section, Rano Ganastrahan. It was upon the foundation of Searstad Éireann, the Irish Free State, in 1922, however, that the translation section was officially established by order of Dáil Éireann as the section of Parliament responsible for, among other things, the official translation into Irish of primary legislation. The establishment of Rano Ganastrahan was a direct reflection of the nationalist ideologies prevalent at the time of the foundation of state. This was a new era in the development of the Irish language. The role of Irish was changing, and as the Irish people's sense of pride was emerging with the development of the Irish nation, the widespread use of Irish in Ireland's business was a basic element in the promotion of Gaelic culture. The revival of the Irish language was to the fore in the recreation of this Irish Ireland under the new government, and a non-lingual translation of all aspects of Irish life ran parallel to Rano Ganastrahan's legislative translation work, the revival not only of the Gaelic language but of the Gaelic nation. Throughout the 19th century, the Irish language had retreated from its position as the everyday language of the majority of the country. By 1900, more than 99% of the population were fluent in English, with 85% unable to communicate in their so-called native tongue. At the end of the 19th century, Irish as a living language appeared to be fated to become extinct within a rather short period of time. The Irish language movement established in the final quarter of the century, however, ensured that this did not happen. As Garage O'Tuathaí describes, the new independent Irish state was determined from the outset to assert the distinctiveness of Irish cultural identity and for a key cohort of the political leadership of the new Free State, the Irish language was the cornerstone of that cultural identity. They had been to school at the Gaelic League. The primary elements of the language policy adopted by the new state were as follows: the maintenance of the Irish-speaking community of the Gaeltacht, the promotion and revival of Irish in the overwhelming English-speaking country at large, ensuring basic competence in Irish from those working in the public service, and standardising and modernising the language itself. As Pádraig O'Regan has it, the ultimate objective of Ireland's Irish language policy was the establishment of a bilingual state, and it was in pursuit of this agenda that Ranó Gan Aisteachán was first conceived. After founding of the state, increasing use of Irish in many domains created the need for technical terms not available in the language, and the lack of appropriate terminology required in the various domains in which Irish language was now being used proved to be a great hindrance to the promotion and revival of the language. The elevated status afforded to the language upon the foundation of the Free State in 22 meant that Irish was henceforth to be used in all matters of state business, politics, legislation, education and civil service activity, areas which required a certain level of terminology in order that the state affairs could be professionally and properly fulfilled through the medium of Irish. It can be said that official Irish language terminology planning also began with Ranó Gan Aisteachán. In order for Ranó Gan Aisteachán to translate legislation into Irish, it faced the challenge of developing a legal language in Irish, which in the early years entailed much basic terminology work such as coining new terms, standardising existing terms and differentiating between synonymous terms. By coining terms for current usage and by granting official status to that same terminology, an intrinsic step was taken towards the revival of Irish as a modern European language. As O'Regan highlights, there is no doubt that it was Ranó Gan Aisteachán who made the most notable advancements in tailoring the Irish language to fit all aspects of the 20th century, particularly in the field of new terminology. Clarity and singularity of use and meaning are the two most important characteristics required by those who use technical terms, two characteristics which separate terms from those words which are in common usage in the language in general. Such singularity of use and meaning is particularly essential in the translation of legislative texts, where equivalence of legal terminology is fundamental not only to ensuring fidelity to the source text, but in order to safeguard against divergence from the original legislation. This is of particular relevance in the Irish context due to the constitutional status of the Irish language as the national and first official language of the Republic of Ireland. Article 8.1 of the Constitution of Ireland, passed by plebiscite in 1937, states that the Irish language as the national language is the first official language, and the provision in Article 25.4.6 states that in the case of conflict between the text of a law enrolled under this section in both the official languages, the text in the national language shall prevail. In other words, should the Irish language translation deviate in any way from its English legislative counterpart, it is the Gaelic translation which has the legal upper hand. As such, in the case of the Republic of Ireland, the Irish language translations are not only pieces of legislation in their own right, but hold a unique position in that it is the translation which is given both semantic and legal precedence over the source text. How then do Ranó Gan Aisteachán undertake terminological endeavours in this legislative translation work? When Ranó Gan Aisteachán was first established, the translators were dependent on whatever books were in print at the time and on their own Irish in order to help them in their work. They would have discussions among themselves in order to follow the same practices as regards terms and phrases most commonly used in legislation, and from this they began to compile terminological lists. Those notes and any acts which were already published in the same area were the first port of call for terminological patterns. For example, if someone were working on a translation of a financial act, that person would consult financial acts which had been published in previous years in order to access terminological precedents. These terminological lists eventually grew and developed and were assembled into 4 volumes, referred to as 4 masters, with 2 copies of each of these volumes available in the office in order that translators could search for an English precedent and its Irish version and find the appropriate reference. These terminological lists continued to be kept, and in the 1960s index cards were designed with the English language terms on the cards in alphabetical order, and later electronically converted for an internal database around 15 years ago. Towards the end of the 1990s, the Office of the Attorney General began to electronically convert all the English language acts, and a legislative book was made available, now accessible via irishstatutebook.ie. And at the beginning of this century, the Irish language acts were collected and made available on actina.ie. Since 2005, Rannog has been using a specially designed facility directly connected to the internal version of the site actina.ie. The precedents are then searched for in the acts, and the text is imported into the document afterwards. The internal databases exist for the different translations being undertaken at any given time. As such, primary emphasis is placed on following terminological precedent, the primary source of which being the acts themselves. This approach has been described in an interview between Una Bratna, who now works in Finter in DCU, and current chief translator of Rannog and Astrahan, Vivian Ivaha. For the Rannog, most of the basic terms we use have been created for a very long time. And our main aim from a terminology point of view, and this is very important for legal translation, is to ensure that the terms we've already created and used, that is, the precedents. Precedents are very important to us here, and it's our business in terminology in general to ensure that we're keeping to the precedents we've laid down for ourselves in the Acts and in other legal documents that we've supplied up until now. Given this reliance on precedent, there's been little need for new legal terminology since the earlier years of the Free State. For example, in legislation pertaining to social welfare, Sahar will always be used for benefit, and Luntus will always be used for allowance, and as Ivaha has described, we will never depart from that. Such a reliance on precedent within Rannog and Astrahan has, however, meant a divergence in the terminology employed by the Rannog and other government agencies, as one Rannog translator has described. I personally feel that there is a tradition in the Rannog stretching back, probably to the period when it was first established, of basing terms as much as possible on native roots. For example, Farahan is used in the Rannog for monitoring, although it is likely that Monitoracht is the most common version in other places. As such, while legal terms employed in Rannog and Astrahan translations apparently represent something of a terminological standard, one term for one concept and no divergence from set precedent, this also means that the terms employed do not necessarily represent those which are in common modern usage, and may also in other cases be entirely archaic or contradict the vice of An Costa Termiacta, the Irish Language Terminology Committee. This may perhaps be as a result of the fact that Rannog and Astrahan has never provided a terminology service proper to the public. O'Rourke in particular has criticised the fact that Rannog and Astrahan has never shared its terminology with the Language Committee, stating that despite working diligently for 70 years and sorting a plethora of synonymous terms, Rannog and Astrahan has never shared these equivalent terms with the public, except in Termí Lee and in a small booklet titled Phrases in English and Irish, Abertí, Merlagus and Gaelic. This exclusivity and certain reluctance to share terminology has, in O'Rourke's opinion, led to confusion as to the correct terminology, and as a result, difficulties in translation, stating that the person who coins the second term certainly doesn't know that there is already one in existence. That statement is true for terminology in use in legal text, whether national or European Union, and much of the fault lies with those organisations which did not publish their terminology for many years. The publication of Termí Lee, meaning legal terms, in 1957 was a vital step towards the dissemination of official Irish language legal terminology, though it was not without its limitations. As a collection, it is rather inadequate, having been compiled only from 10 orders and containing many words which are not legal in a technical sense, thus diluting the value of the collection as a whole. While Termí Lee had the potential to transform the language, it needed to be supported by all other agencies. Yet its contexts were not endorsed in Dwaldria's 1959 English-Irish Dictionary, nor in the New Comprehensive Grammar published in 1960. No direction was given in the publication as to how to employ the terms given in a legal domain, and there was, on the whole, a complete absence of litigation through Irish at this time, meaning that the terms were not tested in court. Rather than helping to consolidate Irish as a modern language, Termí Lee was never reissued, updated or supplemented in order to encourage such litigatory action. O'Rourke is particularly critical of Termí Lee, describing it as a damp squib, a flying star which appeared briefly in the firmament before imploding and disappearing without a trace. O'Cassaget, however, asserts dissemination of terminology is not the role of an Rannog, stating that the first thing to state about Rannog and Astrahan is that it is not a service for the public, as its primary role is to specialise in a very limited area of legal terminology and ensure legal and terminological consistency with existing legislation. As such, the coining of terminology by Rannog and Astrahan is merely a byproduct, the immediate priority being its use in legislation rather than its provision in an accessible format to the public. And Nvaha describes this. We here do not have a planning role. Ours is an executive or practical role. Our job is to produce a product, and at the end of the day we're under pressure to do even that, to provide things to a high standard and in a timely fashion. And the first thing that happens to those terms is that they're inserted into the document that's being prepared for publication, an act or doll paper. We have to do that work on a daily basis. What we do with the terms that are created in that case, be they new terms or precedents, we put them into the product we're providing. That's the first thing. Terminology in this case is an activity in the realisation of a name, translation, and it is true that Rannog and Astrahan's role is not that of a terminology agency. Since the beginning of 2008, however, Finter and DCU has employed selected Rannog and Astrahan translations in order to compile term lists for iate.europa.eu, the EU's multilingual terminology database, which I'll cover in further detail later on. As part of this project, Finter collect legal terms in Irish and make them available to the public. And to this end, Irish language versions of statutory instruments from the years 1976 to 1981, translated by and chosen upon the advice of Rannog and Astrahan, have been, along with other legislative texts, aligned in order to create a translation memory and parallel corpus of legal terms available online at gish.ie. Despite this, it is noted on the gish.ie website that some terms in this collection are not to be found in any of the main language terminological sources. Although they may be of interest to the researchers and translators, it should be noted that the only status they currently have is that they were extracted from the aforementioned statutory instruments. They will not have official status unless they are approved by An Costi As such, where Rannog and Astrahan insist on precedent, those legal terms which they continue to employ may no longer have any authoritative status unless made official by An Costi further adding to the argument that an adherence to terminological precedent in the Rannog may equate to a move away from popular modern usage. Despite this adherence to precedent, however, some acts of the Oireachtas, as translated by Rannog and Astrahan, still contain some semantic overlaps and discrepancies. One particular example is the use of the words cosc and tormach, which in the 10,000 words corpus of acts I analysed as part of my doctoral research can be seen as given translations of the legal terms prohibition, inhibition, prevention and obstruction. In order to ascertain which Irish term best fits the legal meaning assigned to that in the source text, it is necessary to assess the semantics of the terms in English, first in a general and then in a legal context. The Oxford English Dictionary of Law defines prohibition as follows. So the act of forbidding or preventing something, an order that forbids something, or the prevention by law of the manufacture and sale of alcohol in the US from 1920 to 1933. In a legal context, we can take it that definitions 1 and 2 fulfill the requirements of what is meant by prohibition in legislation, insofar as it indicates an authoritative ban or sanction. The noun inhibition and verb inhibit are defined by OED as follows. A feeling that makes you unable to act in a relaxed or natural way, the act of inhibiting. Inhibit, hinder or prevent an action or process, makes someone unable to act in a relaxed and natural way. In contrast, this definition of inhibition has lost some of its authoritative undertones. The focus in this description is on the hindering or impeding of a particular act as opposed to banning it or outright forbidding it, as is suggested with prohibition. The third legal term which is used interchangeably with the above is prevention, which OED defines as to stop something from happening, stop someone from doing something. Prevention here is much more in line with prohibition, although there remains a semantic incompatibility between the two. While a prohibition suggests an official or authoritative request to refrain from an act, prevention suggests a successful attempt to stop the act from occurring in the first instance, and thus differs from inhibit, which implies an attempt at a prevention. The final English legal term, obstruction, is defined as to be in the way of, block, prevent or hinder, an obstruction being an obstacle or blockage or the action of obstructing. This definition is much more in line with that of inhibit. However, while inhibit specifies an action or process, the definition of obstruction appears to be a physical rather than procedural inhibition. It is in these semantic nuances that the importance of equivalence in translation and legal terminology is most felt, as while all four terms belong in the same semantic domain, they are not semantically equivalent. The terminological vocabulary of a specialist subject field such as that of law requires an accuracy which can only be achieved by a term being both monosemous, having one meaning, and mononymous, consisting of one word, as far as possible. While synonymy is a common feature of legal terms in legal languages such as English, which have several layers of language, it is arguably of particular importance for a minority language such as Irish that one English legal term equal one Irish legal term. At the very least, given the pejorative status given to the Irish language in the context of legal translation in the Republic of Ireland, one would expect that a number of legal Irish terms would not be used interchangeably for different legal concepts. As Breckus describes, legal science differs from the natural sciences. The laws of nature are the same everywhere. The difference is evident in the relationship between the language and its object. The language of natural science cannot change reality. If a plant is described wrongly or inaccurately, it remains as it was nonetheless. But if the legislator, in a new law, describes a legal phenomenon otherwise than in an earlier law, then the legal reality changes. Law exists only in human language. In other words, whether a legal term be pure insofar as it only exists in a legal domain, be it sometimes used in other contexts, but have a particular meaning in certain legal relationships, as with our four terms, a legal term enshrined in legislation is afforded legal status and power, which necessitates that it be accurately employed, as to do otherwise is to change the law itself. With this in mind, it's timely to consider the definitions of these terms in a legal domain. The Dictionary of Irish Law defines prohibition as follows: an order of the High Court preventing or prohibiting a body or person from exercising a power which it does not legally possess. Relief by way of prohibition will be refused where the matter raised is properly one of defence. This legal definition of prohibition is in line with that of OED insofar as it necessitates an outright ban of a particular action by way of imposing an order. While this authoritative sanction fits particularly with OED's second entry, and an order that forbids something, the overlaps between our four terms are already seen, as the term preventing is employed in outlining the legal definition of prohibition. The same legal dictionary defines inhibition as an entry in the register of the land registry in respect of registered land in the form of a restriction on registration. The restriction will prevent registrations except those made in compliance with the inhibition. It imposes a subsequent applicant for registration the onus of ensuring that the registration he applies for complies with the inhibition. Inhibitions are used to project interests which are not permitted to be registered as burdens. So in defining inhibition in a legal domain, we see parallels with OED's first entry on inhibit, to hinder or prevent an action or process, as the action in question is not forbidden outright but hindered by certain stipulations. As with our legal definition of prohibition, there is further overlap with our four terms for analysis, as prevent is again used in giving the definition of inhibition. This is particularly of note as the Dictionary of Irish Law does not give an entry for prevention, perhaps indicating that its use in a legal domain is all too rare. Our final term, obstruction, is defined by the Dictionary of Irish Law as follows. Under draft legislation, it is proposed to increase the fine for wilfully preventing or interrupting the free passage of any person or vehicle in any public place. Here, the use of prevention in defining obstruction in a legal context is again a common feature, and as with OED's definition, suggests a physical as opposed to procedural hindrance by specifying the free passage of any person or vehicle. As such, our legal definitions of our four terms appear to be very much in line with those in OED, with the term prevent a common thread. Our only source of official legal English-Irish legal terminology, Termíd Lee, which I previously mentioned, gives the following entries for prohibition, inhibition and obstruction, with prevention again omitted. As you can see on the screen, Termíd Lee gives Tormashc as a translation equivalent of prohibition and of inhibition, yet inhibition alone for Tormashc as a lone term and vice versa. Cosc, however, is the given entry for obstruction alone and is the only consistent term of the four in both the English-Irish and Irish-English sections of Termíd Lee. Adding to this terminological inconsistency, an unofficial source of legal terminology, a book called Focal sa Church, gives the following entries for prohibition, inhibition, obstruction and prevention. So, as with Termíd Lee, the only consistent term in Focal sa Church is that of Cosc. However, while in Termíd Lee, Cosc is the given translation of obstruction, in Termíd Lee, Cosc is the only Irish equivalent of prevention. Prohibition, inhibition and obstruction are all given solely as Tormashc in the English-Irish section, yet in the Irish-English section of the same book, obstruction is omitted as a translation of Tormashc. Furthermore, under the verbal noun Tormashc, inhibit is excluded where obstruct and prohibit are included, and the verb ban added where it had been omitted in the noun form. This is a bit confusing. Tormashc. The use of prevention as an equivalent of Cosc is reiterated in Focal sa Church, which gives Tormashc as the given equivalent of obstruction in the English-Irish section, yet a search for Tormashc in the Irish-English section of the same publication only gives inhibition and prohibition. Termíd Lee itself, having only been based on 10 acts, is neither sufficiently comprehensive nor modern enough to use as a terminological basis for English-Irish translation. It has been long out of print, it has never been reissued, amended, expanded or supplemented, yet it has been incorporated into Terma.ie and its sister site Gish.ie. Secondly, while the publication supposedly represents a systematic attempt to provide an exhaustive official list of core legal terms in Irish, it is a modest collection which O'Rourke describes as having O'Rourke is described as a modest collection upon which only a very limited form of litigation could be envisaged through the medium of Irish. This, paired with the apparent confusion as to what Irish legal term answers the same legal term in English, leads to questions as to how robust Irish language translations are in a legal domain on a national level. Now on to the EU. How then do such terminological difficulties translate on an international level? Upon Ireland joining the EC, as it was at the time, on January 1st, 1973, the Irish language acquired unique status as a treaty language of the EU. This particular status was granted as a result of the Irish government having turned down the offer to have Irish as a full working language, and the official reason given by Ireland's negotiators in 1972 was that its use as a full EU working language could give rise to certain practical difficulties. As such, only primary legislation, such as the Treaty of Rome and subsequent treaties, were translated into Irish, the Irish versions of which being, from a legal point of view, as equally authentic as the versions in the other official working languages. This treaty language status also offered several possibilities for the use of Irish within European structures. For instance, there was a possibility to correspond with the EU institutions in written Irish, and the Irish language has been a possible language of the European Court of Justice since 1973. However, for over 30 years, not one appeal was made to the Court of Justice in Irish. This is not to say that Ireland did not interact with the court, merely that when they did so in English. It was another 30 years, however, before Irish was granted the status of official language of the EU. The preamble to this regulation from 2005 indicates that the addition of Irish was effected upon the request of the Irish government and stresses that Irish is an authentic language of the treaties. It also draws attention to the fact that under the Irish Constitution, the Irish language is the first official language of Ireland. As such, on January 1st, 2007, Irish became a full official language, making it the 21st official EU language and the only language that has been reported as the EU's official language in a different year other than the country's admission date. Moreover, it is the only EU language that is not spoken by a majority of the population in any member state. It was agreed by the Council, however, for practical reasons and on a transitional basis, to introduce a 5-year derogation on the use of Irish in practice in the EU institutions. That derogation came with the possibility of being prolonged unanimously by the Council for additional 5-year periods. The derogation itself means that the institutions of the European Union shall not be bound by the obligation to draft all acts in Irish nor to publish them in Irish in the official journal of the European Union, with the assumption that DG Trad, the translation section, work towards acquiring a full ability to provide a comprehensive language service, translation service. The 5-year period of derogation for Irish was later extended in 2010, justified by the fact that there were difficulties in recruiting Irish language translators, lawyer linguists and interpreters. A further extension was provided for in 2015, for a period of 5 years between January 1st, 2017 and December 31st, 2021. The Council stressed that EU institutions should continue their proactive approach to increasing the availability of information in Irish, and as such indicated that the scope of the derogation should be gradually reduced and would not be extended beyond December 2021. This is of note for 2 primary reasons. Firstly, having thus far existed in something of an administrative limbo, the current push to end the derogation phase of full implementation of Irish as a working language of the EU by 2022 means that English-Irish legislative translation will see a similar surge in activity in the next 5 to 10 years as that in the first years of the Irish Free State. Secondly, the quality of legal translation into Irish must be further ensured on a European level when it acquires full working status a century after the foundation of the Free State, and as such exactly a century after many of these legal terms were first coined and used in legal translation. How then are terminological decisions in Irish language translation made in the European institutions? Firstly, FINTER and DCU has a role, again, in assessing this process, primarily through the Irish Language IATE project. So IATE stands for Inter-Agency Terminology Exchange. The partners of the Irish Language IATE project are FINTER and DCU, the Irish Government, so the Department of Arts, Heritage and the Gaeltacht, if it's still called that, and the EU institutions. This project was set up with the purpose of making available relevant and reliable terms in the official EU languages in order to support the multilingual drafting of EU texts. Prior to the inception of the IATE project, the various EU institutions and bodies managed terminology work in different ways, meaning that work was being duplicated and inconsistent or redundant terminological data was being created, in some cases even within the one institution. In order to counteract this duplication of terminology and as a cost-saving measure, work was begun in 1999 on the creation of a terminology database which all the EU institutions would take part. The Irish language strand of the IATE project was initiated in 2007, the Irish language having got official EU language status that year. The results of this work are also available on geesh.ie. So when undertaking translations in the European institutions, there are various sources and resources used by translators which are given a particular order of preference, as you can see there. So you have to give sort of first place to any primary legislation if it exists in Irish, then to any legislative documentation mentioned in the regulation you're translating, then to published legislation, IATE, as previously outlined, Terma.ie, which is also run by FINTER, and then lastly to Acts of the Oireachtas, so Irish legislation translated by Ranó gan Astrahan. In order to further assist ourselves in translation, both at the present moment and in preparation for the end of derogation in 2022, we've begun to translate the Acquis, which is the body of all European legislation published to date, and which Ireland has not been obliged to translate due to its previous status as treaty language and because of the derogation itself. The primary reason for this is to add to the body of Irish language translations and terminology in order that there'll be a more substantial corpus of Irish language translations and terminology to draw from when the workload becomes larger at the end of the derogation. Translations of the Acquis, however, are accessible only by translators and lawyer linguists on Euromis and will not be accessible by the public nor legally binding. While this is a worthwhile endeavour and of great support as translators, there's one particular difficulty pertaining to the translation of the Acquis, primarily that references have been made to the Acquis in later translation which have been translated and are legally binding, referencing legislation which had not been translated and for which no terminological decisions had been made. As such, various translators could feasibly translate the same term or even the title of the legislation in different ways, as that translation hadn't ever been translated and hasn't been assigned the appropriate official terms, feasibly leading to terminological difficulties. Sustained efforts are made to avoid this occurring where more than one translator is working on the same translation project, which would usually be a lengthy piece of legislation. In this event, the project is assigned a KTS, so Coordinator Termiachta agus Stíle, so stylistic and terminological coordinator, who is a translator from the unit who's responsible for checking the translation memories and making recommendations as to adding extra documents to the memory, creating a spreadsheet for any stylistic and terminological decisions regarding the project. Where a revision to the text is to be made, the KTS must find out if there is an Irish language version of the regulation available, and if so, if that regulation has later been corrected, and to ensure that that regulation is in the correct place in the memory. Fourthly, to find out if there are any references to other legislation in the document and whether or not there are Irish language versions of those documents available. And finally, to keep those working on this, all those translators working on the same project up to date with any terminological or stylistic decisions made. In the event that there are various possible options for the translation of one particular term, it is up to the KTS to consult published legislation. An upside of that is that this means sometimes their terminological work has been done for them. A downside is that in the event that the KTS does not agree with the term in the published legislation, that previous terminological decision cannot be unmade and must be followed. In the more rare event that the same term be translated in two or more different ways in published legislation, the KTS must then choose what he or she sees as the most appropriate choice for that piece of legislation. Similar to the role of the KTS is that of the Ifigach Termiachta or Terminology Officer. So in each Irish language unit in each institution, we have an Ifigach Termiachta who'll be a translator from that unit, and they'll be responsible for the safeguarding of terminology within that institution. So while one person is responsible for this in the Irish units of the European Commission and of the Parliament, in the Council this is a rotated role and each of the translators get a chance. The Refugee Crisis have an interinstitutional meeting twice a year at which terminological decisions are discussed and made, and the decisions of these meetings are shared among translators in the different institutions on an intranet site called the Wiki. Similarly, throughout the year, the European institution translators and lawyer linguists and those in Finter and DCU have access to an online terminology forum and Teishling, where they are invited to share their thoughts and knowledge on different terms for which there is not an official Irish language translation. With all these measures in place in Europe to safeguard terminology and translation, what terminological difficulties then do Irish language translators in the EU institutions encounter in their translation work? One example is where the English language term may hold various different connotations or express meanings depending on the context, such as with the verb or term conduct. While one term in English may be employed as regards conducting research, conducting electricity, or conducting an investigation, the semantics of the term dependent on its context are not to be missed in legal translation. Legalese often plays a role in this confusion, employing a higher register term such as conduct, where a simple do would suffice in English. As such, often jan is the appropriate translation in Irish, while in other instances the verbs seolu, lanchal or sturu are more befitting to the context. Another issue can be confusion between the semantics of a term in a legal domain as opposed to that in general speech, such as those in the aforementioned examples from Rannog and Astrahan. One more recent example of this in Europe was the Refugee Crisis of 2015. The Irish speakers among you will be familiar with the term chefach as the term most commonly employed online and in Irish language media in reference to refugees. The legal definition of a refugee is as follows: a person who, owing to a well-founded fear of being persecuted for reasons of race, religion, nationality, membership of a particular social group or political opinion, is outside the country of his nationality and is unable or, owing to such fear, is unwilling to avail himself of the protection in that country. As such, the qualifying conditions of a refugee in law are the presence outside their home country, a well-founded fear of persecution, and incapacity to enjoy the protection of one's own state. In FGB, O'Donnell's Irish English Dictionary, however, a chefach is defined as a runaway or fugitive. In legal terms, a fugitive can also be known as a wanted person who is either accused or convicted of a crime and hiding from law enforcement in that state, or by taking refuge in another country in order to avoid arrest. As such, one must be careful not to confuse the two terms in legal translation. FGB gives Gini as the appropriate term for refugee, which is also to be found in Irish language versions of the primary legislation. For this reason, Gini is used in EU institutions as opposed to the more commonly recognised chefach. Another consideration is following terminological precedent, or what may be described as the EU institution's house style. A particular term may come to prevalence which may be translated in a number of ways, but where one of those options is already in use for a separate term. For example, in legislation pertaining to asylum seekers, a reference is regularly made to the term relocation. Again, the Gaelgory among you may automatically translate this as athlonu, which would be a perfectly adequate translation if it were not for the fact that athlonu already exists in translated European legislation as the equivalent of resettlement. As such, this is translated as achi by Irish translators in the institutions in order to respect the variation between the two terms, however slight that difference may be. Having discussed what has been done as regards English-Irish legal terminology both in the Republic of Ireland and in the EU, it is pertinent to ask what is left to do. The extent of Rannog and Astrahan's impact on the modern Irish language is not easily articulated. Their role as regards language revival and renewal, modernisation and standardisation of the language, their sheer body of translation work, and, as we have seen here, the creation of a legal language and terminology in Irish was absolutely central to the promotion of Irish as a modern European language. However, as we have also seen, and as Cronin has stated, translation is never without consequences. One of the failures of the revivalist movement in post-independence Ireland was to assume that translation was transparent and that a natural ability to speak and write Irish lay below the thin anglicised veneer of translated Irish. What is of note, however, is that in almost a century of English-Irish translation of legislative material in the Oireachtas, the extent of these consequences has never previously been examined. Here we have seen the disparity between different sources of Irish language legal terminology and issues regarding the dissemination of those terms. Inconsistencies occur not only within published terminological sources, but also from institution to institution and within the legislation itself, evidence of which has been seen in the few examples given today. This raises questions as to the level of equivalence not only between the English and Irish legal terms, but as to the equivalence of the laws themselves. As stated during a contemporary Dáil debate, there is no difficulty about finding Irish translations for technical terms, but on account of the very nature of technical terms, a dispute may arise as to whether any particular translation conveys a technical meaning assigned to the original English term. Almost a century on from the establishment of Rannog and Astrahan, and at the brink of the removal of derogation currently in place in implementing Irish as a full official working language of the European Union, it is important to reflect on what what lessons can be learned from the Dublin experience and its impact on English-Irish legal translation and terminology today. Certain shortcomings still exist pertaining to the efficacy, consistency and dissemination of Irish language legal terminology. This may only be remedied by the implementation of rigorous standards as to English-Irish translations produced by Rannog and Astrahan in a manner echoing that of the European institutions. Enforcement at government level, a full cooperation between the terminological institutions in Ireland and in Europe with a view to standardisation of Irish language legal terminology, and the dissemination of that standardised Irish language legal terminology in a manner which is accessible to the public and which will be reviewed on a regular basis in order to preempt recurrence of these same issues. There we go. This would have an impact on the standard and efficiency of English-Irish legal translation, both in the Republic of Ireland and in Europe, and feasibly in Northern Ireland, where the current high-profile campaign for Irish language legislation since the 2006 St Andrews Agreement has played an integral role in toppling the power-sharing executive at Stormont and remains central to the ongoing political impasse. Should such statutory provision for the language in the public life of Northern Ireland be made, there is potential for studies such as this to inform that process as regards English-Irish legal translation.